This is Bloomberg Law with June Grasso from Bloomberg Radio.
Our stockholders have approved the ratification of the 100% performance-based stock option award to Elon Musk that was approved by stockholders in 2018.
Hey, guys.
It was a mutual love fest at the Tesla shareholder meeting. Of course, Elon Musk loved the shareholders for approving his massive compensation package of $56 billion.
I just want to start off by saying, hot damn, I love you guys. Yeah.
And how could the shareholders not love a CEO who offered a pie-in-the-sky projection that Tesla may one day make around $1 trillion of profit annually from a humanoid robot called the Optimus? That's not even in production yet. But 72% of Tesla shareholders approving the largest CEO pay package ever doesn't make it so. Joining me is business law professor Eric Talley of Columbia Law School. Eric, were you surprised that shareholders voted in favor of resurrecting Musk's pay package from 2018?
I wasn't surprised with the outcome. I think most people thought that they probably were going to eke out a victory on both of these proposed measures. Just the pay package is one of two major ones. The other was reincorporating into Texas. I think I am a little bit surprised by the margin of victory. You know, back when shareholders were first asked to approve Elon Musk's pay package back in 2018, there were no votes. It passed at about 73%. This time, it passed at almost exactly the same percentage. So I was not really surprised at all at the outcome. I was a little bit surprised that it wasn't a little closer, however.
So was it a vote of confidence in Elon Musk or a vote of fear that he would distance himself from the company?
The answer to that question is yes, June. It probably was a little bit of both. Clearly, it's the case that Tesla wanted this as a kind of a trophy vote of confidence in not only in Elon Musk now, but in Elon Musk back then and in the board back then. You know, it's not clear, and it probably won't be clear for some time whether this vote has any effect on the legal holding about the permissibility of his 2018 pay package. But by the same token, it's really hard to ignore if the stockholders who now have complete possession of all the information that the judge said they didn't have, they go back even after he's rendered these services and say he deserves to get this pay package. So, I think Tesla and Mr. Musk want to treat this as a strong vote of confidence. And I think in some respects, that's helpful to them. It's not clear that it's going to flip the entire legal case. It's a little late to come out to have a big bearing on an opinion that's already been rendered, but it could help them a little bit in an appeal. It could help them on the attorney fees award. The downside is the question of whether there were any other defects in this vote.
When Delaware Chancery Court Judge Kathleen McCormick voided the pay package early this year, she pointed to the board of director conflicts of interest and the company's failure to promptly disclose the terms of the plan. With this vote, did Tesla make the proper disclosures?
The standard formula for getting a shareholder approval or a shareholder ratification of something that involves a conflict of interest is to make sure that the shareholders, when they vote, they have all the information they need to have, and that they don't feel like they are voting with a gun to their head or a metaphorical gun to their head. And with this second vote, Tesla basically threw in everything but the kitchen sink in terms of the disclosure to stockholders. They talked at length in their proxy solicitation about the process that they didn't talk about in the early one. They even appended the entire opinion from Chancellor McCormick. So the question of whether stockholders were informed this time around, I think, is not even a close call. They were, in some ways, if anything, they were over-informed. But the problem is that on some level, Tesla went at such length to concentrate on the informed part of the vote. There was a cow that got out of the barn a little bit on the is a gun being held to your head. So the other key criterion for a vote to kind of have a legal effect is that it not be coerced. And this turned out to be kind of a problem that sort of metastasized a little bit leading up to the vote, with Mr. Musk saying, not only will I be sorely disappointed and might even disengage from Tesla, but I might just direct AI and robotics to something else. And in fact, I went out and I raised money on AI and robotics through an independent entity that I might or might not direct back into Tesla. So that's a little bit more than just sort of saying I might just disengage and quit. I might take something or take assertive actions to take some business opportunity that, on some level is very much the identity of Tesla, right? That these are effectively mobile data collecting computers. That's effectively what they're making that also can transport you from place to place. And to sort of say, hey, that's business opportunity. I may, get so disillusioned that I'm just going to divert that elsewhere. And that then becomes a little bit of a problem because the question really is, does this vote, at least from a legal perspective, can we interpret it as counting if the stockholders had a little fear as to whether they were going to be able to say no to Elon Musk without kind of shooting themselves in the foot? And so to the extent that Tesla or Mr. Musk now will turn around and say to either Chancellor McCormick or the Delaware Supreme Court, you need to give this legal effect as kind of a replacement stockholder vote. There is an obvious challenge that someone who is resisting it might put up and say, this was a nice, strong mandate, but it was exacted, under the shadow of a potential threat to do harm to Tesla, or at least to Tesla's future business prospects if the vote didn't go Mr. Musk's way. From the standpoint of just optics, sort of the PR image of stockholders voting to approve of Mr. Musk, it clearly has some utility. But there is kind of this interesting question about whether the stockholders felt like they had much of a choice other than to vote for Mr. Musk.
But then there are the stockholders who seem infatuated with Musk, part of the fan club that I'm sure would support him no matter what.
It's pretty clear that several of the stockholders really just are part of a kind of an unflinching and infinitely faithful Elon Musk pep squad or something like that. But, there are some others that probably are a little bit more calculating in their approach, particularly in the years going forward. And it's conceivable that some of those said, I don't really, do I want to get on this guy's bad side? It looks like he might turn around and kneecap the company if he doesn't get this vote. So I'm going to kind of hold my nose and vote for this thing.
Will Chancellor McCormick now reopen the case and consider this stockholder vote?
I think it would be really hard for her to do that. Now, the case has not reached a final order, so it still would be possible for her to do it. But literally the only thing left is the argument that's going on right now about attorney's fees. And so I could easily see this vote working its way into that argument to basically say, hey, listen, Chancellor McCormick, you have to award attorney's fees to the plaintiff's attorneys in ways that are somehow scaled to the benefit that they have created for the company. The plaintiff's attorneys said, hey, canceling $56 billion worth of pay, that's value that goes back to stockholders. So that was the value we created for the company. So give us a fraction of that. I certainly expect that the defendants, Tesla and Mr. Musk, will say, hey, wait a second. If that was such a great value that was created, why did these stockholders turn around and say, no, we really do want to give it to him because we think that it's in our best interest if he's made happy? Maybe they didn't create $56 billion of value because, the stockholders kind of are all sort of signing on to the idea that he really deserves this money and they want to keep him happy. So I think there might be at least one immediate use of this vote as a way to say, Your Honor, you shouldn't view the value that was created for the company as the whole $56 billion because, after all, 73% of our stockholders said we want to give it to them anyway. We don't view it as a net benefit from our perspective. And so that, I think, could easily come up. Could they use it to go back and say this undoes the infirmities in the vote that occurred in 2018? They might try. Chancellor McCormick herself, in a late May ruling, basically said to the attorneys, you had your opportunity to reserve your rights to do that now, and you're telling me you're not going to do it, and if you then turn around and do this because the vote goes in your favor, I'm going to be irritated, to say the least, at you. And so I think that this will probably, to the extent it has effect, with Chancellor McCormick, it's going to be in the attorney fee perspective. But then they might try to use the stockholder vote as a kind of a complementary sort of occurrence to help them if they were to make out an appeal to the Delaware Supreme Court, right? There are several grounds that they might try to appeal the opinion, and it's not going to hurt to be able to say, oh, and our stockholders agree he deserved this money, and therefore let's judge some of the more inventive things in the opinion against this most recent stockholder mandate.
And the stockholders also approved the move from Delaware to Texas. Musk, never one to let an opportunity to mock go by, posted a picture of a cake that said Vox Populi, Vox Dei, and said sending this cake to Delaware as a parting gift. As far as the pay package, let's start with that. Let's say he loses in on appeal in Delaware. Would Tesla have to start from the very beginning to get the pay package for him in Texas?
So the answer to that question is going to be an irritating, it's not entirely clear, too. Part of the reason
I get those a lot. I get those a lot.
It's a very lawyerly answer. You sort of say it depends, and it buys you a few more minutes to think about what an answer is. So here's the deal. It is the case that now Tesla is a Texas incorporated entity, and therefore decisions that they make from today going forward are going to be judged under Texas law. Decisions that were made when Tesla was a Delaware company are judged under Delaware law. So if they exhaust their appeals and they aren't able to flip the outcome in a way that they like, that doesn't preclude various measures that they might take as a Texas company. So, for example, might they say, shareholders, Delaware turned us away, that's why we came to Texas. We would now like you to approve a compensation package that is in retrospective, that is made out of gratitude to Mr. Musk for all the growth that he put the company on, and we want you to vote for it now. And if they vote for it and approve it, I'm going to guess that someone's going to come along to challenge it, and then it's going to be subjected to Texas corporate law, which is a body of corporate law that not a lot of people knows much about and certainly has not confronted this type of issue before. And to the extent that Texas, has had to deal with a bunch of executive compensation issues before, it's not uncommon to see them citing to Delaware law as instructive on how Texas is going to deal with it.
Hold that thought, Eric. Coming up, we'll find out more about the chances of the pay package going through and some other legal problems Musk is facing. This is Bloomberg. Tesla investors offered votes of confidence in Elon Musk despite a sales slump and falling stock price, reapproving Musk's record-breaking compensation package of $56 billion and approving Tesla moving its legal home to Texas.
Welcome to the Tesla shareholder meeting. And I just want to start off by saying, hot damn, I love you guys. Yeah. We have the most awesome shareholder base. I mean, it's just incredible. Any public company, it's incredible. Wow.
The pay vote is only advisory and doesn't guarantee that Musk will get his stock options. A Delaware judge had voided the payout in January. Tesla is expected to appeal. If that fails, moving the company's incorporation to Texas allows the board to revive the pay package in a new state with potentially more favorable courts. I've been talking to business law expert Eric Talley, a professor at Columbia Law School. Eric, before the break, you were talking about how Texas courts are just starting out in the world of business law.
There's all kinds of interesting questions about, is this now a moment where Texas law, under the auspices of a brand new business law court that it is currently literally trying to put together right now, is that going to yield a kind of thing than what we see in Delaware? And the answer is it might, right? It may well be the case that, Texas is going to try to brand itself as the place where the Elon Musks of the world want to incorporate, because we're not going to, let irritating things like investor protections and shareholder votes stand in the way of getting what you want to get if you're a iconoclastic, founder or CEO of the company. So it may be that Texas just decides, okay, this is our chance to author a law that is going to stake out somewhere on the spectrum on how protective of investors we're going to be versus how solicitous of CEOs and boards we're going to be. And we're just going to stake out something that is a little bit more friendly to the Elon Musks of the world than Delaware has. It's interesting to note, though, that there are a lot of people who have over the years criticized Delaware for being too friendly to the CEO and board of director types. And so Texas would be going even further. It wouldn't be the only state that did it, right? Nevada famously has tried to make a push in this direction as well. And, you could imagine that if Texas law does go in that direction, it could potentially attract other companies to Texas. Now, whether it succeeds in doing that or not is another question, right? The fact of the matter is, if you're an already formed company, it's really nice if you're the CEO or the board not to be subjected to a bunch of, what you might view as pesky, shareholder litigation complaints. But by the same token, if you back up a stage to the point where you are raising money from people, saying, please invest in the company, and we want to make a credible promise to you that we're not going to, misuse your funds, spirit them away, use them for our own private dalliances or some other company we are in control of, it's sometimes good to be able to say, hey, we're incorporated in a state that won't let us do that. And so if Texas were to stake out a much more permissive ground to let CEOs and boards do whatever they want, does it then kind of ironically enough make it harder for those same CEOs and boards to get people to part with their money at the point of investing in the company because they know they're not going to have as many protections down the road?
I don't think Musk is thinking about that aspect of it. He's just thinking Delaware has been so hard on me and Texas might be different, especially because my company is here. And of course, in other areas, Texas judges have been known to depart from the strict rule of law, shall we say. So maybe the judges there will be a little easier on him.
Yeah, I think there's a good chance that they will. And, one of the things that'll be interesting to see play out is not only this sort of question of whether the iconoclasts like Musk want to reincorporate in Texas, but whether some of the more humdrum CEOs, would want to do that as well, right? The thing that's definitely special about Mr. Musk is that he can sort of push to pay himself a very, very large chunk of the company's value and still have folks who are basically unflinching in their loyalty to him within the stockholder base. That's generally not true for almost all other CEOs out there. They don't have, kind of an almost religious following amongst people. So it's going to be a harder sell, it seems to me, for slightly less superstar-like CEOs to convince their stockholders that moving to Texas is going to be great for everyone. But I certainly wouldn't be surprised if Texas, now having been handed one of the biggest companies in the world as a company to be in its charge at a point when it's now trying to redefine its own business law, might end up crafting that business law in a way that's a little bit more friendly to what Mr. Musk has already experienced in Delaware, even though a lot of that was pretty consistent with, decades-long Delaware law.
Speaking about some Tesla shareholders' unflinching loyalty to Musk, no matter what he does, will that be tested by a lawsuit that was filed last week? Musk and SpaceX were sued by 8 former SpaceX workers, accusing Musk of overseeing a pervasively sexist culture and animal house environment. And the Wall Street Journal reported last week that he had had sex with an employee who directly reported to him and a college intern and asked a woman at his company to have his babies. So now it's a lawsuit. And when one suit is filed, often others follow, as you know. So one wonders if he'll be held accountable in some way.
Yeah, I mean, listen, there's a small allegory from the Old West, right, which was you can seem invincible in a gunfight until you're suddenly not. And so you never know when, sort of the end of the, sort of the benighted, sort of lucky streak is going to happen. And for all we know, it may go on for several years. But realize that, some of these allegations do not center themselves in Delaware corporate law. They're like federal type of claims. You don't get to escape them simply by reincorporating in Texas or Nevada or even outside of the U.S. because they apply to where are you doing your business. And much of that, if not all of it, most of it, I guess, is in the U.S. So in some ways, the recent events, and we might see more as well, are going to at least stress test the cult of personalities and the attachment that much of Mr. Musk's sort of army seems to unfailingly have towards him. At some point, the gold plating may wear off of that. And when that happens, it is almost always difficult to predict, but it can, and it can happen relatively quickly. So, there is a sense, by the way, and in fairness to Mr. Musk, he's, essentially put himself out there as a very visible person. On some set, of measures, I guess he's willing to be judged by his track record. But, some of these events are also part of his track record. And so are they going to, sort of die down over time? Who knows? They certainly don't give one the flavor of thinking that, these alleged transgressions are all, far into the background. And so it will be, I think, an ongoing, at least backstage drama, if not front of stage drama over the next couple of years. And, we'll see how Tesla weathers the storm. He's been remarkably resilient, not only in the business community, but also, on the regulatory and legal side of being able to fend off these challenges. But like I said, the worm can turn quickly in these situations as well.
To put it in legal terms, you mentioned Musk being able to fend off regulatory problems. Musk announced the successful vote the day before the official announcement by the company. Would the SEC see that as a problem?
It was an interesting thing. You hardly ever see this when you've got proxy votes coming in. And so there are some people who will just wait until the shareholder meeting to vote their shares. But some people who basically say, no, I'm going to give my proxy over, maybe even to the CEO or a member of the board, and this is how I want them to vote my shares. And so, and that's typically what will happen in some of these circumstances. So, members of the board and Elon Musk had a lot of these proxy votes already in their possession, and he posted before the stockholder meeting that they had already passed the threshold on both of these initiatives to gain a stockholder mandate under each of them. And there's kind of an interesting question about whether that itself is problematic. You never see it occur. That you usually, you wait until all of the live votes are tallied up, and then you try to figure out who won. And usually you kind of know who won before the live votes are tallied up. But as a general norm, you don't make the announcement ahead of time. It's kind of like the controversy we saw years ago with, exit polls, right? Where, the press would go out and they'd take exit polls of people who vote early in the day. And then it would discourage people from showing up later in the day because they already knew the outcome, or they thought they knew the outcome of the vote. So, would this have changed the outcome? Probably not. Might some federal regulators be interested in whether this was a type of a manipulation of the proxy rules? I expect they're looking at it. I don't know how much is going to come out of it. But the last thing that's kind of interesting, and we talked about this earlier, at the very beginning, the first question you asked me is, are you surprised at the outcome? And I said, well, I'm surprised at the margin of victory here. And they're, pre-announcing, oh, yes, we're already over the threshold. There's nothing that can change the outcome of this vote. Might that have actually caused this margin itself to go up, right? Might it be that some people who were going to vote no when they thought that, this is going to be a close call, I'm going to show up and vote no, they just don't show up. Or they show up, but they say, I'll go ahead and vote for it because I can't affect it anyway, so I might as well, add to the mandate. And to the extent that that's true, and to the extent that Tesla is going to depend on the size of this mandate as being something that signals a strong message from stockholders, it's not obviously in their interests to have leaked the ultimate outcome the night before the actual stockholders meeting, and thereby possibly ginning up more of a mandate than they would have gotten otherwise. And so you could imagine that coming into play, particularly in, maybe softer questions of how should we interpret the size of this margin of victory? Was it a margin of victory that itself was subject to some degree of manipulation?
And where was his Twitter sitter, one might ask? Thanks so much, Eric. That's Columbia business law professor Eric Talley. Coming up next on the Bloomberg Law Show, the trial of exiled Chinese tycoon Miles Guo for swindling investors out of $1 billion. And the luxury lifestyle prosecutors say he bought with that. I'm June Grasso, and this is Bloomberg.
Welcome to an undisclosed location in Texas, Miles. It's a pleasure to have you here.
Nice to meet you, sir.
Nice to
Thank
meet
you very much.
Yeah, well, we met before. I've become friends quickly.
I'm very part of.
Me too. We share some similar views and come from very different angles, but we're going to have a great time today.
4 years ago, hedge fund manager Kyle Bass interviewed exiled Chinese tycoon Miles Guo. Now Bass may be a witness against Guo at his fraud and racketeering trial in a disclosed location, federal court in Manhattan. prosecutors accuse Guo of swindling more than $1 billion from investors by tricking them into funding 4 bogus schemes and then spending the money on lavish gifts for himself and his family. We're talking about a $26 million New Jersey mansion, a $37 million yacht, a $4 million Lamborghini, a $60,000 TV, and a $35,000 mattress, to name a few. The defense says that Guo lived that lifestyle long before he was alleged to have committed these crimes, and that being shallow or rich does not make you a criminal. Guo now resides at Brooklyn's Metropolitan Detention Center, quite a step down from his $68 million penthouse in the Sherry Netherland Hotel. Joining me is Ava Benny Morrison, who's covering the trial. Ava, tell us about Miles Guo, who's also known as Guo Wengui.
Miles Guo is a tycoon from China who has been living in exile in the US since about 2015. Since then, he has built a really strong following online, denouncing the Chinese Communist Party, the CCP. And through that, he's been able to encourage a lot of his followers to make sizable investments in a few different investment opportunities he was touting, from crypto to farm-to-loan programs and even his own social media platform. When he was arrested last year in New York, he was living in the famous Sherry Netherland Hotel overlooking Central Park on the Upper East Side. His lawyers in his trial, which has been going on for the past few weeks here in Lower Manhattan, have tried to stress to the jury that, look, just because he's rich and he likes the finer things in life doesn't mean he's a fraudster. They've said that he grew up in a really wealthy family of real estate developers in China, and he's always been used to having nice things. And this didn't happen because he was swindling people out of money.
What's the government accusing him of?
So Miles Guo is accused of ripping off investors to the tune of $1 billion. And he allegedly did this by encouraging a lot of his online followers to invest money in a few different investment opportunities that he had going on. One of them was a social media platform called GTV. Another was a crypto ecosphere called the Himalaya Exchange. And another one was a farm-to-loan program. In one of the cases, he allegedly took $100 million worth of investors' money and put it towards a hedge fund to bet against the Hong Kong dollar, which unfortunately for him failed. And he is also accused of spending a lot of his victims' money on very, very nice things. We're talking a $26 million mansion in New Jersey, a $37 million super yacht, a Ferrari, a $35,000 mattress as well.
And my favorites, the Bugatti and the Lamborghini, plus the $60,000 TV. So is the defense saying he got this money from family funds or he earned it? Where did it come from?
We haven't had a look at the defense case yet because the prosecution is still going. But from the outset, from the defense openings at the start of the trial, they have said that he's always been rich his whole life and he has access to a tremendous amount of wealth. The prosecution has combated that and said, well, before he was arrested, authorities in Hong Kong and China had actually seized his assets. And they say that's why he was cash poor and he was looking for more funding to keep his extraordinary lifestyle going. So there's two sort of contrasting pictures being presented here in front of the jury.
And does he have political asylum here?
He applied for a political asylum after moving to the US in 2015. His lawyers have told the jury that he is the subject of an Interpol red notice by the Chinese government, so he can't go back to China, otherwise he'll be arrested. They've also said that the Chinese government have targeted his wife and his child. They've hacked his computers, his bank accounts, his cell phones, and they've tried to sort of portray the picture of a man who is brave and courageous in going up against the CCP and uniting all of these people who want to push back against what they see as a pretty aggressive regime in China.
And in reading your story, I remembered where I heard his name before. He has connections to Steve Bannon and MAGA.
Yes, one of the interesting parts of this trial has been seeing the people that Miles Guo surrounds himself with. He was quite close with Donald Trump's former advisor, Steve Bannon. When Bannon was arrested himself a few years ago, he was actually on board Miles Guo's super yacht off the coast of Connecticut. Miles Guo also had a professional relationship with hedge fund manager Kyle Bass, who may or may not testify at this trial. We're waiting to see whether he pops up at some point. And every day when Miles Guo appears in court, there must be 3 to 4 dozen people all crammed into the courtroom in support of him. During the breaks, he'll turn around and he'll wave at the people that are sitting in the public gallery and smile and giggle at them. So he's certainly got an entourage that turns out to support him every single day.
So the judge has taken the really unusual step of ordering that the jury be anonymous?
Yes. While Miles Guo has all of these supporters, there have been a handful of them who have been quite vocal and at times protesting outside of the courthouse, holding signs, yelling things at witnesses as they walk outside. So the judge has taken the unusual step of ordering that the jury in this trial be escorted to and from the courthouse every single day. They use a different elevator in the building to what the general public uses. And Miles Guo has argued that, yes, that's necessary because he is a target of the CCP and therefore they should be protected. But the prosecution says you have these very passionate and loyal supporters who have been acting out at some of the prior court appearances, and the jury needs to be protected from any other further instances like that.
And Ava, part of his persona was as a fierce critic of the Chinese Communist Party.
Definitely. That's definitely at the heart of this case, that he was this self-proclaimed crusader against the CCP and the CCP regime, but at the same time he was using that platform and the support base that he had amassed to commit this fraud and to swindle people out of more than $1 billion. When I've been sitting in court and listening to one or two victims who were really attracted to Miles Guo's tough stance against the CCP, they said that they were watching his online videos, his YouTube sermons, and they just became really fascinated with him and then ended up investing money with him because they trusted him. I heard from one woman the other day on the stand who described him as a liar, someone who can't be trusted, who is a cheater. And when she was giving that testimony, I could hear some of the people that were sitting behind me sniggering. So I think that he does have this really strong support base and people who may not have lost money like some of the witnesses who are testifying against him.
Now, his former chief of staff, Yvette Wang, pleaded guilty on May 3rd. Do you know if she's going to testify against him?
I'm not sure, actually. I don't think so because she didn't have a cooperation agreement.
And are most of the witnesses who've testified so far investors or others?
Yeah, there's been a real mix of people who have testified so far. We've heard from investors who gravitated towards Miles Guo after watching his online videos. One woman invested about $15,000 and she lost all that, which was a big amount for her. We've heard from people who worked for some of Miles Guo's companies, including someone who was working at Citibank and handling his company's business accounts before he actually left that job and joined one of Miles Guo's companies during the pandemic. We've even heard from a Ferrari dealer who was talking about a very exclusive sports car, of which there's only 40 made in the world, that Miles Guo allegedly bought for millions of dollars in 2021. So it's been a real mix of people who are testifying on behalf of the prosecution.
Yeah, he had some very nice cars there. Prosecutors have sought the forfeiture of the mansion, the yacht, bank accounts, a Bugatti, a Lamborghini, and a Rolls Royce.
Yes, exactly. And one of the FBI agents who was testifying early on in the trial actually talking about when she was at the house during the search warrant at Miles Guo's house, and there was mention of Italian suits hanging up in the wardrobe and a ridiculously expensive car parked in the driveway, documents with a super yacht. So, yeah, he certainly likes the finer things in life.
His wife and daughter live in Connecticut, but he's being held in lockup?
Yes, his wife and daughter live in Connecticut, but Miles Guo is currently in custody at the MDC in Brooklyn. He's been there since he was arrested in early 2023.
Could he be deported to China? Do you know if that's part of it?
As a non-US citizen, that's always the risk when you're arrested and charged with a felony. If you're convicted, there is a real likelihood that you will be sent back to the country of your citizenship. So that could certainly happen here. And if there is that red Interpol notice out for him, like his lawyer argues, he could be facing a whole other judicial process over there.
Does he speak English, or is the whole trial being translated for him?
He does speak some English, but it's quite basic from what I understand. He has he does speak some English, but it's limited. He has a few translators in court every day and is wearing headphones, and the translators are obviously listening to what the witness is saying, what the judge is saying, and the lawyers, and then it's being translated for him in real time through the headphones that he's wearing.
And how long is the prosecution's case expected to take?
It's been going for 4 weeks now, and it was only about halfway through as of last week. So we expect to see a couple more weeks of the prosecution case, and then we'll hear from the defence. The judge expressed some concern this week that the prosecution was taking so long, and then she's decided that the trial is going to sit for a couple more extra hours each day this week so the prosecution can really make some headway.
It's going to be so interesting to see who the witnesses are for the defense. And I know you'll be there, Ava. Thanks so much. That's Bloomberg legal reporter Ava Benny Morrison. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.